Good morning.
Good morning.
I am an attorney. I represent management. Been doing that for a bit more than 30 years. And a part of that has been developing and administering drug testing policies and all the various aspects that flow in and out of that. The thing that I like to start out with is to jump right into drugs. And typically they're referred to as the drugs of abuse in the workplace. Some of which are part of the standard drug test. But the main issue that I like to point out is that depending on the substance, when you go through a test and they measure concentrations in your blood, those measurements don't have anything to do with impairment. I'll probably say that maybe 12 times today. That's a critical issue. And part of that, alcohol, 24 hours, it's out of your body. So alcohol is different. But you get into marijuana, can be up to 36 days. And the levels of concentrations vary among people that have heavier use and lighter use, or a first-time user and so forth. Something like amphetamines could go up to 14 days. PCP, 2 to 5 days. Something like, where did I have it here? Cocaine, up to 2 weeks. So if you had an employee or an applicant that had used one of those substances within that time frame, they very well could have a positive result on a drug screen. But it doesn't mean impairment. And there's only a handful, opioids, amphetamines, cocaine, marijuana, and I don't remember the other one, that are typically part of the panel that drug testing resources provide for employers. I think if I remember, it's 5 that are part of the federally regulated workplaces, people that do commercial motor vehicle and so forth. So what's the point of having, why do you have a drug testing policy? Does everyone in here have an employer or your company that does have a drug and alcohol testing policy in place?
Yeah, sure.
Okay, who doesn't? Anybody? Okay. Well, interestingly, there seem to be more employers in recent years who, in some cases, aren't even adopting policies at all. They're just attempting to manage the issue without a policy in place. What is the reason for having a drug testing policy? It's to enhance safety. That's what we're concerned about. In the United States, both safety and the related goal of saving costs or avoiding unnecessary costs are really the things that drive the public policy, which then supports the notion of drug-free workplaces. And so in terms of enhancing workplace safety, some of the things that may not always come directly to the front of your mind are, with a good policy, you can promote independent correction by employees. So if you have a policy that states and a practice of allowing people to come forward if they think they have a problem, to self-identify, say, gee, I think I have a problem, I might need some treatment or whatever, might need help connecting with health insurance programs for treatment. Sometimes Supervisors cringe. You could call and say, oh, somebody came in and they said they got a problem. What am I going to do? Do I have to fire them? I said, heavens no. You don't want to fire them. This is one of the benefits of a policy that promotes coming forward. And it's much better to have someone self-identify and get help than to have someone end up being impaired and hurt themselves, hurt someone else, cause property damage, et cetera, et cetera. Obviously, among the goals are reducing accidents and the related costs, whether that's a workers' comp kind of an issue or a property liability issue. And it is also interesting to go back to the beginning of all this when we talk about drug testing, because most people don't know what the evolution of drug testing was. And remembering that a positive drug test does not equal impairment, how did we get into drug testing? Well, the historical basis for drug testing came from studies indicating that people who used illegal drugs were willingly taking fairly serious risks. You can, if you're caught using drugs or possessing most unlawful drugs, you might end up in jail. I don't know what the numbers are, but hundreds of thousands of people have ended up in jail for violations from everything to crack and heroin and those things to marijuana across the board. But the translation of that's a risk behavior into drug testing was that statistically, someone who is willing to engage in a high-risk behavior is statistically far more likely to engage in other high-risk behavior. So I'm going to be, taking whatever, cocaine. I'm going to be high, and I'm going to, whatever you get out of cocaine, I'm willing to take that risk. That's a person who would be more likely to say, oh, I'm just going to run the machine without the guard, or if I'm driving, I'm taking chances driving, taking unnecessary risks that put either people or property in jeopardy. And I talked about the fact that what feels like, and this is not statistical, or this is just my own impression from talking to employers, but what do you do if you don't have a policy? And it probably doesn't apply to anyone here, except these pieces are applicable even if you have a policy. But without a policy, what do? And it's, you observe, you pay attention to your employees. If someone is stumbling around, slurring their words, acting frenetic, off for whatever reason, pay attention. Verify. One supervisor says, oh, I think Larry, something's wrong with Larry. He's, I don't know what's going on with him today. I tried to talk to him and he's like staring off into the corner, and I don't think he was paying any attention. I don't know what's going on. Well, then have somebody else check Larry. Just go up and engage. And if there's an indication that there's a problem, then bring the person in for a meeting. And again, you want to have two supervisors in the room, one to speak and one to sort of sit over to the side and watch. Does the person make eye contact? Are they behaving in a way that's consistent with who they are under normal circumstances, whatever that might be? Make those observations. If based on that, you take the two supervisors out, well, or send the employee out, one or the other, and you say, yeah, something's going on. Now, we still don't have any idea. We have two people that think something is off, something is not right. What is it? Well, then you go and you ask the employee. You say, hey, we're concerned because you're not with it today, or you're distracted, or whatever it is, what's going on? And of course, if someone has been using alcohol or drugs, they'll say, well, I've just been using alcohol or drugs and I'm high or loaded or whatever else. That's all it is. Obviously, they'll say that. But if there is no explanation that makes sense, then part of what you would do based on that additional close observation is make a call. If you think there's a basis for testing, and again, what are you testing for? And alcohol and drugs are different, as we'll talk about in more detail later. In a context where you don't have a policy and someone will not have signed a consent, you probably have a consent form and ask them, if you're going to test them, say, we want to arrange a drug test, and here's a consent form, we want you to sign it. Yes, it's coercive, but it's permissible. Also, if you're doing testing, and you'll hear this again, and everyone in this room knows this, but if you think someone is off and maybe under the influence of drugs, whether over-the-counter, prescription, illegal, or alcohol, you don't say, okay, now, it's down on 14th Street, and you go down there and turn left, and then you report for testing. And as an aside, and everyone in this room also knows this, but when it's all said and done, after they've been tested, you don't say, okay, now, go home for the rest of the day and send them out to their car to drive home. That's the same thing that sometimes is the one that people miss, getting caught up in the testing process. And then the last thing you do is whatever follow-up is necessary. You may not have tested, you may have figured out everything was all right, it may have been a different kind of an issue, it might have been a fitness for duty issue, trouble with the spouse, can't sleep, under stress, somebody lost a job. It could be someone in the household that has a problem with substances or alcohol that's causing difficulty. So it could be a lot of different things. It could be someone that's upset, exhausted, or possibly even other psychological kinds of issues. But if the question is, if the behavior was sufficiently questionable that you've gone through this process and you're not comfortable that they can safely return to work, then you could take them home or arrange transportation home and try again the next day if there's no need for follow-up. If there is a need for a follow-up, whether that's disciplinary, corrective, whatever, you want to do your documentation and go from there. You'll be familiar with all the aspects of the approaches to drug testing, pre-employment, reasonable suspicion, which is sort of the big one that we're talking about. There's so-called blanket testing, which I actually haven't even heard of for a number of years outside of doing these kinds of conversations. But that's basically just where you say, okay, we're just going to test everybody. It's obvious it's not random. You're testing everybody in the building, managers, supervisors included. We're all being tested. There used to be more of that. Accident testing of one kind or another. It might be periodic testing, something like happens again with commercial motor vehicle drivers. They need to have a test every so often, or at least to have been subject to a test by being in a pool from which they could be selected for a test, and then that rotates, and some people get tested every time, other people seem not to get tested at all. And then finally there's random testing. There's nothing to do with anything other than, whatever, you've got a hat, got a nice top hat, and you put people's names in it, shake it up and reach in, and the winner is, the person gets a drug test. Random. Alcohol testing. In Oregon, all the way back in the early 70s when breathalyzers and toxilizers were coming into use with law enforcement, the legislature, which had a very strong union representation then as well as now, said, oh my goodness, employers are going to get these machines, they're going to run around having all their employees blow into the machine and try to catch people who drank the night before or whatever it is, and it's just going to be a disaster. So Oregon has a quite unique law on alcohol testing. And it's expanded beyond the notion of the actual breathalyzer and toxilizer, whatever that technology has evolved into today. It's basically any alcohol testing. You need one of two things. You need a reasonable suspicion that the person is under the influence of intoxicating liquor, or you need consent. Now in this context, this is why we said when we talked about testing, if you want to do a drug test, you don't have a policy that someone's already signed off on, you'd have a consent form and say, yeah, sign this. And you could do that. Sign this. The implication is if you don't sign it, you're in trouble. Then essentially that's like refusing to take a test under a policy. But with alcohol, the difficulty is that it's virtually impossible to get a voluntary, knowledgeable consent if you think someone has been drinking or maybe intoxicated, but don't have reasonable suspicion that the person is under the influence of intoxicants, and that's a fairly heavy standard. And so whether that's a pre-employment context, then you can get consent because you are not in an employment relationship, which is inherently coercive, because if I say, do X, it's your own choice, you can decide. If you decide not to, you're fired. That part isn't said, it's just in my demeanor, even though, it would be in someone else's demeanor that's more intimidating and scary. But this is employers that come into Oregon, and I don't know, it's not fun, I was almost going to say the most fun. California companies that end up putting a branch in Portland or Medford or whatever it is, and they say, oh yeah, we just want to check and make sure we're consistent with Oregon law. And when we come to their drug and alcohol program, they just have random testing for alcohol. We say, yeah, no, Oregon is not going to work. It is to test someone without a viable consent or a demonstrable, reasonable belief that they're under the influence of intoxicating liquor. It's an unlawful employment practice, so it's essentially the same as sexual harassment or firing someone because they had an on-the-job injury. Same section of the law, same kinds of issues. And no questions? We're all rocking and rolling? Yes?
So, smelling of alcohol on someone's breath in the place of employment, provided they're not acting strangely, is not probable cause?
Well, it depends. If they just have alcohol breath, that's probably not enough to form a reasonable belief that they're under the influence of intoxicating liquor. You would typically, as a practical matter, and people are familiar with alcohol, it's been lampooned and it's been in cartoons, and so we know about alcohol. People get flushed, they slur their words, they might be off balance. They often smell like alcohol. But if it's only the smell, that probably by itself isn't enough. Because maybe you had a drink 4 hours before you came to work and didn't brush or do anything else, and you still smell like that. Or maybe you spilled some on your shirt and didn't change or clean up, and you're there. Now, and I would come to this later, but this is a good time to talk about it since it came up. That doesn't mean you do nothing, because the drug and alcohol policy is one area, but there are complementary kinds of policies and work rules that apply. One of the very typical ones to think about, which isn't part of this immediate conversation, would be something like a search policy. Under what circumstances are we going to say we want to check anything that you're carrying or whatever, your lockers, your desk, whatever? You should have a policy that lets people know what your expectations are and what level of privacy they are entitled to expect in their locker, desk, what have you. The other policies that come into play are fitness for duty. And again, with people who are safety oriented, I assume that's a fairly automatic. Does everyone's employer have a fitness for duty policy in the handbook?
Yeah.
This is just a policy that basically says you're expected to report for work ready and able to do your job safely, competently, and if you are unable to do that, then you're not fit for duty and you could be sent home, and depending on the circumstances, that would be more. Could be disciplinary or something pre-disciplinary potentially. And this could be like the situations that we were talking about. Someone is off. There's nothing that leads us to believe that it's an alcohol issue, a drug issue. What is it? Maybe they're tired. What is it? Some of these other things. Well, they're not fit for duty. That's where that comes in. The other policy, which off the top of my head, I would say fitness for duty issues seem to come up less often than issues under the other related policy area, which is appearance and grooming. And that always gets people excited. Probably 5 or 6 years ago, we had a battle with a union that lasted about 1.5 years, when an employee who drove, an operating engineer, came to work, actually came to this is a public employer as well, came to a meeting of the county board, and as soon as he left the room, the entire board was going, what the, this guy's not driving, is it? What's going on? And they called the manager of the department this guy worked for and put all these things in play. Well, there wasn't any indication that he had actually been drinking or that he was under the influence of intoxicants, but he smelled like a distillery. Now, regardless of whether you're intoxicated or not, if you are representing your employer, you're interacting with customers or the public in general, and you smell like a distillery, that's almost universally unacceptable. And so even though we might not have sufficient cause for testing, we might not think of it as a fitness for duty, that they're not able to perform their duties safely and responsibly. But if they are not appropriately groomed, which can mean breath, body odor, clothes ripped up, and whatever else, it can mean all kinds of things. But basically, that means that a person is not presenting an appropriate professional or an appropriate for the circumstances employee representative of the employer to the public or to customers. And so in that instance, yes, sure.
Yeah, you addressed some positions may be, scrutinized more closely based on your position within the company if you're at the front end with customers. the jobs that we do, that I'm speaking specifically of, I mean, we're not air traffic controllers.
Okay.
But we perform routinely medium to high risk jobs. So if we get off the target just a little bit, we can be seriously injured or seriously injure somebody else. So again, I guess you're only going to make a determination based on observation.
Well, observation, verification, sit down with the person if needed. But if the key to that, if there's no, and in terms of, I'm using interaction with customers or the public as an example, that's not exclusive. So even in a group that works in a warehouse on the back of the lot that never sees anybody, they're inside the warehouse, they don't even deal with the trucks coming in, it's not appropriate to smell like a brewery or a distillery, or to be walking around with a cloud of marijuana fragrance wafting off you. Because and obviously certainly not for anyone that's a lead person or a supervisor or a manager, because they have the role model responsibility, but even an employee, because if any employee is allowed to do that, then any other employee may say, well, now what's going on with this? My safety may depend on this guy. He smells like he may be drunk. Now that's a problem. That's a distraction. So I don't mean to imply that it's only those people that interact with someone else. If you're just in a work group, it's problematic.
Well, so what you said, if he smells like he's drunk, smell is a sense, correct? It's not an observation.
Well, it is an observation, but how do you smell like you're drunk? You might smell like alcohol, but you're not going to smell like you're intoxicated necessarily.
So if I'm called in by my supervisor and he says, how are you doing today? I can't help but smell what seems like alcohol on your breath. And right then, he stands up and he says, I'm contacting my attorney. This is discrimination.
Who the employee says that?
Yeah. because I'm not acting irrational. I'm not doing my job, performing my job in a safe way. You're making your basis on what you smell and not what I do.
That is true. And if you have a complementary policy on appropriate grooming and dress, you're covered.
Okay.
As I say, but it can. Exactly what you are saying is what happened with this situation in this union, because the union representative was in management's face and then in my face for almost a year. By the time it got to me, saying, "Oh my goodness, you're saying he was drunk." Saying, no one has ever said he was drunk. If he would have been drunk, he probably would have been fired. Here's the document that he received as a warning notice telling him that smelling like alcohol was unacceptable, contrary to the policy, and if it happened again, he'd be subject to disciplinary action. So someone may be, in a situation like that, I would put that on hold and talk to your HR people or have them call the person that you deal with that's like me, that deals with employers and this kind of stuff. I don't remember that I've ever seen it or had a question come up about it, but it is conceivable that there are people with skin conditions, for example, that might be bordering on a disabling condition that would need accommodation, that might, to other people, smell funny. There are prescription medications that cause weird or different and potentially offensive to some people odors. And in this day and age, anything medical related, virtually all of those kinds of entities Now you're not permitted to have perfume or cologne or deodorant with a scent. I mean, they actually incorporate that into written policies because people, their patients may have sensitivities to or be offended by, and or employees. Employees may have allergies, or, all kinds of things can possibly happen. That's stretching out a bit from the person that smells like alcohol. And, if that person is saying, well, I'm going to call my attorney, an employee has an absolute right to call an attorney. If an attorney ever were to call on behalf of an employee, though, what do? You say, here's our attorney's name and phone number. It's been nice talking to you.
Thank you.
Sure. Are we, where, what? Oh, question.
You had mentioned about cologne and deodorant.
Yes.
I work for a client who prohibits cologne or deodorant because they have close proximity. So they recommended using a mixture of vinegar and water as your deodorant because it doesn't leave an odor. And yeah, really.
Okay.
Yeah. No, you put it on cotton, you mix it in a bottle, pour it on cotton and wipe, and then you don't have the odor, but it controls your.
You smell like a pickle.
Okay, well, and let's see. Let's see, where am I? 23. Yeah, some of the legal issues that are connected to this area of drug and alcohol testing, again, depending on circumstances, but it can get into invasions of privacy. Search is an example. You don't have any kind of a policy. You're suspicious that Jeanette has, alcohol in her locker, and you just go and use the whatever you call those things, those loppers and bolt cutters. That's what I'm looking. Thank you. Grab the bolt cutters, cut off her lock, go in there, and say, you've got a bottle of gin in here. You're fired. Well, that possibly could be problematic depending on whether or not you have policy or practice that supports that. Right, whether someone reasonably expected that what was in their locked locker with their own lock was private and not subject to being checked out by a supervisor or manager. Defamation can come into play. Basically legally publishing, meaning saying to someone else, or in writing, obviously, as well. False information that's damaging to reputation. I assume we've all heard at some point or other the phrase that people throw around, truth is the ultimate defense. It's sort of true, but it's only truth that's demonstrable, and that's where you get into trouble sometimes. An example, if you think someone has stolen from you, and these are very frustrating cases, employers, for whatever reason, get upset when people are stealing from them. It almost is taken personally. And they go through all this stuff, and they say, okay, we know who it is. There's no question. We're going to call them out and tell them they're a thief and fire them for being a thief, and going to make sure they don't get unemployment and blah 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 blah. Report them to the police and whatever else. I say, okay, what do we got? Well, gee, we've had thefts on 4 occasions, and on 3 of them, this person was on duty. Okay, this is not proof. So the truth isn't going to save the day in that kind of situation. In terms of drug testing, The fact that someone has a positive drug test does not make them a drug dealer, does not make them a drug addict or a drug fiend or whatever else. And so those kinds of issues, which can arise internally, someone has loose lips, that's a supervisor that's aware of somebody's drug testing result, says something to someone else, and the rumor mill goes, and it's, oh yeah, Jerry is a druggie. Well, Jerry may or may not be a druggie, and if he's not, that could be a problem. And you don't need to have improper intent. You can believe that Jerry is a druggie or a drug addict in good faith. It doesn't make any difference. You don't have to publish, spread, repeat information with the intent to cause harm or undermine someone's reputation. One of the more recent ones that I've seen came from a completely bizarre place. Someone had a workers' comp claim. A supervisor was interviewed by SAFE in this case, and it was a stress claim, so those are always complicated. And I have no idea what this person was thinking, but when this person was interviewed, this manager actually was interviewed, out of whole cloth said, oh yeah, well, yeah, this woman, the state took her kids away. So yeah, she's really stressed, yeah, and it broke up her marriage. It was like, in fact, no kids had ever been taken away, no marriage had ever broken up. Marriage breaking up probably isn't that big of a damage to reputation. State taking your kids away, that was problematic, because under what circumstances does this state take your kids away? Child abuse, neglect, physical abuse, sexual abuse, serious stuff. And yes, that is damaging to reputation. And someone that makes a statement like that needs to be able to prove that it's true if it comes up. And obviously, if it's false, you're in a lot of trouble. Okay, are we into... Okay, and statutory considerations. This goes into that. Testing results are confidential medical records. In other words, we don't put the test result in the personnel file that's in the open filing cabinet behind the receptionist desk. Confidential medical files, limited access, need to know. However, testing results are part of the personnel record. Am I speaking in a foreign language, or does everyone know what I'm talking about? Under Oregon law, the personnel record is described as basically any record of any kind that an employer or an employer representative has in their or its possession, which is generally used, was used, has been used, could be used to make decisions like promotion, transfer, retention, discipline, discharge. So a drug testing result often is used as a basis for disciplinary action or discharge. That's a part of the personnel record. It is not, not in the personnel file, and there's often huge confusion about that. Employee will request, or more typically an employee's attorney will request a copy of their personnel record. And the client will call me up and say, oh yeah, we got a request for personnel record. I'll scan and email that letter to you, and then I'll just scan the personnel, or I'll scan the material and send it over to you, and I'll get it, and it'll have stuff like, you know, who's your designated insurance recipient and all this stuff. Okay, what have you sent me? Oh, that's the personnel file. That's what they asked for. Oh no. And as just an aside, one of the things that trips up employers in this context is that the personnel record includes supervisors and managers that have their own little personal private files that they don't give to HR, or if there isn't an HR department, that don't go in the personnel file. That's what they use in case they want to do some corrective action or whatever else. They're little, often private files, and those can be, and often are, horrifying, because since no one looks at them, they're very often problematic. Okay.
Question, please.
Yes.
So someone does something egregious, and so the employer puts them under what we call a plan of assistance. And it's a formal process by which you got to comply over a certain period of time.
Yes.
And you comply over that period of time, that term has concluded. Can that document stay in the personnel file, or is that something that has to be discussed up front when the plan of assistance is executed?
Well,
Since you're talking about personnel files.
I have to give the standard employer response. It depends. It could be, if there's enough people, we can pass them down here. Don't look at the paper yet. We're almost there, but not quite. Yeah, I mean, it could be governed by policy, practice, union, contract. There are all kinds of. You just pass it down to yourself.
There's another one here too,
Oh, there is another one. Oh, okay.
not present momentarily.
Oh, I see. Yes.
I was in one of your other seminars where you spoke about personnel files.
Yes.
If you write notes on the jacket, that's still open to, if it's employee challenges it goes to court, that's part of the personnel record.
It's disruptive.
Yeah. Because the employee,
One down.
when they provided all the information, then the employee goes, well, they didn't provide you the jacket, all this information was in. So the attorney requested that, and it was really detrimental to the employee.
And I don't, do any of you manage personnel files? So, and you don't keep your I-9s in there, right? Good. That just comes up, and you don't take pictures of their documentation? Good, all right. Okay, never mind. One of the things that you want to make sure you have in your drug and alcohol policy, and I suspect everyone here has that, is something that addresses prescription over-the-counter medications, because we're concerned with safety. So we're not looking, there's nothing magical about unlawful drugs or whether they're unlawful or legalized, wink, wink. And so that can be over-the-counter medications that are misused or to which someone has a particular sensitivity and reacts to. That can be prescribed drugs that are either taken in a manner inconsistent with the prescription or consistent with the prescription. And so you want to have the ability, if necessary, to, how many of you have a company doctor, by which I mean a doctor that you call and deal with when medical questions come up, like, gee, we've got an employee that's using something unpronounceable. We don't know what's going on. Can this person be operating a machine or driving or forklift or whatever?
They don't have to report that anymore to us.
Why?
I thought that, yeah.
The employee doesn't have to report prescription medications.
We kept it on the down low in our policy, so it's not like when we changed that, we didn't go and say, hey, you don't have to tell us anymore, but they don't have to. Before they would like, if you are on some type of prescription, especially if infected with like machinery,
Right.
they would
Yeah.
come, and so but they don't have to.
How does that fall into HIPAA? Because a lot of times, if you tell me what medication you're taking, I can.
Oh, well,
Medication.
yes, yes. That's a good question. And I don't think anyone's ever raised that. That's never come up. And these kinds of issues do come up. And generally, I haven't ever had a situation where someone objected or that it was problematic or that, and I don't know how often it actually happens. I haven't had a recent case in that area, so.
Came out last year, I think they changed that to the update.
That's probably true. Well, in fact, I will need to check that.
Good question.
Thank you. Now, medical marijuana is not a prescription drug. That's one of the things that creates some level of confusion. Generally speaking, a doctor cannot prescribe marijuana because doctors' prescription writing ability is federally regulated, and under federal law, it's a Schedule I controlled substance, apparently or supposedly or reportedly with no medicinal value whatsoever, and therefore it cannot be prescribed. It cannot be used federally for medicinal purposes. And so you have this sort of convoluted business where if the law identifies conditions, Crohn's disease or glaucoma is one of the other ones, and sometimes PTSD. There's a list, an ever longer list of conditions. So you go to your doctor and your doctor certifies that you have one of the conditions on the list, then you're eligible to go to the state and get authorized to use medical marijuana. So it's not a doctor prescribing. Now, each of you should have in front of you a quick marijuana update. With the legalization, well, medical marijuana is, I'm not sure of this. In the stuff that I was reading coming into this, I feel like maybe it might be as many as 26 states. That might not be right. But it's much more widespread. This last summer, for example, there were 2 cases, both on the East Coast. In Massachusetts, in July, the state Supreme Court, this is at the top of the page, ruled that somebody who had an appetite problem, I think if I remember this was probably Crohn's disease, and the doctor had said, yeah, marijuana can help with that. And so the person qualified to use medical marijuana. Wasn't prescribed, and supposedly it did help with the appetite. So the employer fired the employee, and then she tried to bring a suit, and it was thrown out because marijuana is illegal under federal law. Of course we can fire you for a positive drug test. And the state Supreme Court said, oh no, if the doctor thinks it helps, then it would be reasonable to make an exception to your drug and alcohol policy, which is a bit of a strange decision. The other one, Connecticut, that was just last month. That was a federal court, which is interesting, given that federal law is the one that prohibits marijuana, ruled that a new employee fired after, I think, even 1 day of employment, when her pre-employment drug test came in, she was positive for marijuana. It was, she was using it for PTSD, and the federal court said, oh, no, you can't fire her for that. The reason was that Connecticut actually, the state legislature enacted a law which said that an employer may not refuse to hire or fire anyone for using medical marijuana. And so this federal judge, in balancing the two laws, said, yep, in Connecticut.
How does that fall under fit for duty? Because, I mean, I would venture to say that someone impaired by marijuana, not necessarily you failed a drug test or marijuana.
Right.
How do you know? Should not be operating certain ways.
And if the person is operating a commercial motor vehicle or in aviation, for 2 examples, it doesn't matter because it's federally regulated, and so there's no exception there. In other contexts, if in that state, if you use medical marijuana and it's legitimate, you can't be fired for that. Now, what are you fired for? If you're fired for impairment or unsafe practices in your job, that's a different issue. So it just sort of shifts it. It's not, hands off, you can do anything you want and we can't do anything.
So it essentially,
Exactly, well, and you come back to that.
so it transitions more weight onto the employer for reasonable suspicion.
Yes.
So I think like in our policy, if you get a positive or that impairment or reasonable suspicion and do that, if then falls that they go through like a program to assist them get better, like, so if they deny doing that, going to those classes, whether it be alcohol or drugs, then we can terminate. But if they go through the course and do what's asked of them, then they can keep their employment.
But they're not approaching you on a voluntary basis.
No, they're failing the drug test. Or reasonable suspicion, like they're behaving oddly, so we take them in, and then it's positive, any positive test. Then we say, okay, so here's the rehabilitation or whatever, what you need to do.
But they say they don't need a class because they're taking it for PTSD.
Right, it's medical.
Right, they're not going to want to go through treatment if they're using it medicinally.
So I guess then we would still terminate, because we have a no.
Well, we're in Oregon. We're on the bottom half of the page. So Oregon, medical marijuana in 98, recreational marijuana in 2014, all the way back in 2010, the Oregon Supreme Court looked at this question of reasonable accommodation medical marijuana. And the way that flows is that if you have a covered disability, you can't be discriminated against because you are disabled. And you also can't be discriminated against because of a disability, if reasonable accommodation will enable you to perform the essential functions of your job. That's, we're not going to hire you because you're in a wheelchair. We don't have any ramps. We got stairs. Sorry, you're not being hired. Well, yeah, that's going to be straight out disability discrimination. Someone who's already an employee is in a car accident or whatever, now the person's a paraplegic, and we say, your office is small, the door is small, can't fit under the desk, you're fired. Well, no, obviously not. You expand the door, you raise the desk, or you put a different desk in, or you give them a different office so that they are able to perform their duties. They can get to their desk. That's the easy example. The way that it comes up in medical marijuana cases, typically, not really the way it happened in that Massachusetts case, but generally speaking, you have a condition, whatever it is in Oregon, a condition that's on the list. Those conditions may be disabling conditions that might be covered under the Americans with Disabilities Act or state law on protected class groups. That would be the disability. And then in conjunction with a covered disability, if treatment, medication, whatever else raises issues, then you still can't discriminate against someone. You would have to look at reasonable accommodation. So that's the argument. I have X condition, gets me on the list, access to medical marijuana, and therefore you can't fire me because I'm using medical marijuana because of a condition. Oregon Supreme Court said no, because it is federally prohibited. And there's a statute in the middle of the page that's still in place that essentially an employer may require employees to comply with all federal and state statutes and regulations regarding alcohol and the illegal use of drugs. And you say, well, wait a minute, it's not illegal in Oregon, it's illegal federally. And the employer can require employees to comply with federal and state rules. And so that still is the case in Oregon. So even though the policy underpinnings are sort of teetering because it's no longer unlawful, so arguably using legal marijuana is not different from a legal perspective than using alcohol. And it is so that use doesn't raise this risk behavior propensity like an unlawful drug does. You're not going to end up anymore in jail if you're caught using marijuana. So as a result, my expectation is eventually that's all going to crumble, and it will be not like alcohol exactly, but similar to alcohol, and it'll focus more like in your question, the focus will be much more on impairment or grooming in appearance, someone that smells like a college dorm room 20 years ago or whatever it would have been.
I feel that, so I know that this is still the law in Oregon, everything, so I just really just waiting for the day that we're the next Massachusetts Connecticut case, and I don't want to be that employer, so I'm really hesitant on terminating someone who is doing
Well, but the point is you have discretion in Oregon. Nobody says you must prohibit,
if we're a federal contractor, we have to.
Well, no, yeah, if you're federally required to do it, well, but see, that's it. If you're a federal contract, aviation, commercial motor vehicle, you don't have any choice. You're federally mandated to do that. Eventually, probably not in the era of Jeff Sessions as the Attorney General, who has been carrying on about how he's going to stomp out marijuana use. All right, thanks.